case is Americans with Disabilities Act. And there's kind of a variety of parts to the Americans with Disabilities Act. And my background initially wasn't with getting fired because you had a disability or complaining of that. But this is sort of a newer issue that's come up. It's been going on for a while, but I think about 2 years ago, a plaintiff filed something like 70 complaints on one day against different businesses and entities alleging violations of the Americans with Disabilities Act. And in other states where it's been kind of going on for a while, we're starting to see some of those law firms / businesses that do this kind of roll into Utah. I've had 2 with the same attorney out of Florida now, and he's got another one at our firm as well. And those are a little more concerning because the first guy kind of, I think, saw an opportunity and was looking to make some money, and these law firms are more, they've done it before, they kind of know how to game the system. And so we're going to talk a little bit about that, kind of the difference and how to address these. And so I'm sure some of you are familiar with the ADA. We're talking about Title II here, which is state and local governments. Title I would be the employment part of the ADA. Title III is very similar in this regard, but the way it's implemented under the CFRs is a little bit different. And just so you know. But basically, back in 1991, the federal government passed the ADA. It's pretty sweeping. There are already some government regulations that were similar, but this kind of put it in place for everything. And so the dates to know, which these are not all the dates, but especially where you're looking at older buildings, anything built or remodeled or altered or significant repairs between 1992 and 2012, if it's still in that same condition as the reconstruction or altering or whatever, and it applies to the 1991 standards, for the most part, you're okay there. However, anything that happened after 2012 that was remodeled, or something that was remodeled before but it's not up to the 1991 standards, now has to be brought up to the 2010 standards. I know this is confusing, but the date's 2012. And so those are kind of the ideas, and when we get into defending these cases, that's going to be one of the first things we look at, is whether it was up to the ADA at the time it was constructed or remodeled, and whether it needs to be fixed or addressed or changed. And just so you know, I tried to create a really detailed PowerPoint, and I won't hit everything, but that way you can use it as a handout if you want. And there's a couple other PDFs that I sent to Alex that are too big to print off. One was 280 pages, and I'll give you a link for it, get those two, but there's a couple of resources that are broken down pretty well, and you may be aware of those already. Okay, so for our purposes, we're going to be looking at Title II, and we've been calling these ADA cases kind of drive-by ADA cases. I think literally on those 70 cases, you could kind of see on the map how we'd gone up State Street, all these businesses, and gone in and figured out some things. There was a lot of parking lot where they saw from the road, there's no van accessible sign, pull in, look at the slope, look at the bathrooms, and then file a complaint. And so and technically, that's okay. If it's a violation and a disabled person goes in there and tries to use the facility, and there is something that affects that, then that's going to be a violation. Now, realistically, I think the judges are a little bugged by this. In terms of no warning, they don't give the employers or the landowners any time to address things, but that's kind of the reality. So they visit the facility, they write a complaint, generally it's in federal court, and at that point, that's when the expenses kind of start, right? You call me, you call Kristen, We've got to look at the complaint, we've got to answer it. We have to have somebody inspect the facility. A lot of times, that's you guys, and that's fine, just talking to us and telling us what's going on there. For me, for what we like to do is get an idea of what repairs need to be done and how difficult that is, because that will apply to kind of our analysis of the case. Some of the new issues we're seeing is that the plaintiff is then sending in their expert to look at it, which they have a right to do under the rules of civil procedure. But those expenses they pay to an expert are damages on the back end of a case if the plaintiff prevails. And so that, in at least one of the cases I had, significantly drove up the settlement cost because they got to pay their expert, right? They got to pay this guy. And so getting to a point where we can address it quickly on the front end can really save time and money, and I think dissuade these people and attorneys from continuing to file, especially in counties where there's multiple buildings, multiple situations. You know, if it doesn't work out or how they want it, you're at less chance of a repeat. You know, come back in and see what's happening and have to deal with another complaint later on. Regardless, in these cases, the defendant's going to have to pay to address the repairs. Well, within reason, and we'll get into that. But if repairs need to be done, that's going to come from the defendant. And what we've been doing in some cases, if we can get the repairs completed quickly, we can tell the court, look, there was a violation, now there isn't, the case is moot, right? There's nothing going forward. And in Utah, they have been allowing us to win some of those summary judgment motions, and also saying that the plaintiff did not prevail in that case because it was moot, right? It wasn't a determination that the plaintiff had prevailed, which means they don't get their fees and their costs, which in a lot of these cases are the biggest part of it. You know, some of these repairs are really minor. And so that may not always be the case. It kind of depends on the cases, and some of those have been a little simpler, but that's why we want to look at what repairs need to be done quickly, and we may be able to address it in a little bit faster. And like I said, that also may dissuade these people, these attorneys, from targeting those buildings if they know, well, we spent $2,000 or $3,000 in attorney's fees and we got zero after summary judgment. It also means that in some cases they're willing to settle for less. If you tell them, look, we already completed the repairs, and I've used that or I'll tell them we're completing the repairs, and as soon as we do, we're going to have a summary judgment motion. And sometimes, if it's a bathroom remodel, maybe it's a few months out, but I don't necessarily tell them when those repairs are going to be done. But that may also lower the cost of settlement, which would, once again, will hopefully dissuade them from continuing on these types of things. Okay. As we're talking about settlement there. Okay. And then, as far as some of this other stuff, I think the other thing we can do is some of the defenses to these cases are, undue burden, administratively or financially. It would affect the program, but the federal government has built in a lot of kind of, if there's an undue burden, you still have to do this, and if it affects this, you still have to do this. And so by showing previous action, an analysis, documented conversations, that type of thing, we also have a better chance just to throw up a defense and say, yes, there's a violation, but it falls under one of these exceptions. But we have to make sure we meet kind of a heavy burden there that the federal government's put on us. And so I also think, even if I think what a lot of people forget in cases that judges are people, there's 5 federal judges, 3 or 4 magistrates. 70 cases means they all got a bunch of these guys' cases, and they know what's going on, right? They can read the writing on the wall. They can see, and of course they try to be impartial, but they're people too. They get annoyed, and so we can put these types of things into the motion to show, look, we're the good guy here. We took steps. We're trying to address these things. We're not perfect. Some of these buildings are 100 years old or something. Then, I think we just we can get the judge on our side a little bit by showing them that no one's trying to, do anything to someone with a disability. We're just working our way through as best we can. That's kind of a theory about law, but I found it to be true in the most part. Okay, and then of course, as now we're 6 years past the deadline for the second one, we're 20-something years, 25 years plus past 1991. The chance of some of those defenses coming into play is going down as there's remodels or alterations or repairs. And so, if there are violations now, we're losing a little bit of our window on saying, well, we fall into the safe harbor provision. Okay, just for your information, this is where the rules are. If you Google 28 CFR, it's the Code of Federal Regulations 35.151. Really sounds like a federal government thing, right? All these numbers and acronyms. That's going to give you the black letter law. If you have a question, it's pretty straightforward. 28 CFR 36, which I don't have up here, is the commercial and public accommodations one. So this is 28 CFR 35 is for state and local governments, which are a little bit different requirements. And then the second line here, 2004 AAG at 36 CFR 1191, appendices B and D, of course. These are going to be the same standards, commercial or otherwise, regardless. There's just some different rules about implementing those and what burden the state has versus the private parties on those. And then we'll talk about each of these individually. In 28 CFR 35.150 is probably what a lot of you heard. What do we have to address for existing facilities, right? What, readily achievable is the commercial one, and what does that mean for state and local governments? What barriers do you have to remove, even if it's from the 1970s, before 1991, there are still barriers that need to be removed. So, existing facilities, generally the state and local governments have a high burden. The first line says it all. We need to do our best to make sure that each program, service, activity, in its entirety is readily accessible and usable by individuals with disabilities. There are some caveats to that. If you have two locations and one of them is accessible and one of them isn't, you gotta be thinking, if one of them's open one day a year that's accessible, that's probably not going to be readily accessible. But if there's an option for someone who needs these services or this program, this activity to get there, that doesn't mean every office you have has to be, accessible for every disability, but there does need to do its best when viewed in its entirety that those are available. And a lot of these haven't been tested, and you may be thinking, well, we only have one office, but things like public playgrounds, other public areas where, you may not have public playgrounds where disabled children can go to every single one of them. And that would be prohibitively expensive, right, to make wheelchair accessible playgrounds, or replace a lot of those where there's a lot of parks and things. But if they're available, and viewed in its entirety, if those are an option, then we're looking at a defense that we can put up if we do get a claim, right? And then it doesn't require that a public entity take action to threaten or destroy historic significance. However, and then of course, I'll get to the last one is, this is kind of the exception that everything falls back on, that the public entity has the burden to show that it would require a fundamental alteration in the nature of a service, program, or activity, or an undue financial and administrative burdens. And that's a high bar. That's much higher than the readily achievable standard that private businesses get, right? And issue with that is even if you can say, well, it's going to cost us $100,000 to put in a wheelchair, make a wheelchair accessible, right? You still have to do everything you can to make it accessible and to make sure that other disabilities can also, people with other disabilities can still access it. And so that's kind of as you're going down and making this determination, even if you come in and say it's cost prohibitive, we can't do it, you have to jump to the next step and say, well, what can we do? You know, maybe one part of the building can't be wheelchair accessible, but we can still put a ramp on the front. You know, we can still move an office from the top floor to the bottom floor. That's, you know, more of a vital service. Those types of things to make it as accessible as possible, right? We're gonna, you know, just because someone wants the corner office, if they, you know, they're a vital person that people have to come in and see, they may have to be in an office that's more readily accessible because it'd be, you know, cost prohibitive to put in an elevator or whatever the situation might be. And then, even if you say there's no way, you know, the hallways are too narrow in this building, it's made of stone, we can't get wheelchairs in there, you have to make sure that you do everything else you can for hearing impaired and all other disabilities. It's quite a wide-ranging analysis. So that's kind of the standard. This, of course, what we talked about before, is if something was up to 1991 standards, okay, so in 2005, let me think, slope is one of the things that changed in 2010. So in 2005, the slope was within the standards of the ADA, and it's still the same slope today. That's where the safe harbor applies. You don't have to bump it up to the new 2010 slope, okay? But in 2005, the slope was not, you know, the slope of the parking lot or the slope of the ramp was not in compliance. You need to, you know, or you put in a new parking lot in 2005 and it wasn't in compliance. And trust me, people say all the time, shouldn't contractors know this? And I don't know, but they don't do it all the time. So even if it, you know, they put it in, now you got to bring it up to the 2010 standard, okay? It's only for things that were in place and within that compliance window. It's kind of a double analysis there. Okay, and then just so you know, 2010 added quite a few things. I picked out a few that might have relation to the county. Fishing piers and platforms, golf facilities, swimming pools, you know, saunas and other things. Those standards were added in 2010. So there is no safe harbor for them. You can't say, well, I was up to the 1991 standard because there was no standard. The federal government won't allow that. And so that's just to remind you of those things, and those are listed in the CFRs. And I know several counties in Utah have golf courses, and that's why I put it in there. And there are a few other that may apply or may not as you look at those, but that's really the only caveat in the safe harbor. Okay, methods, you can probably figure these out yourself. There's a lot of things you can do. You can reassign, you know, services to other buildings, to other areas. You know, you could open a satellite office once a week. You know, the question is kind of like readily accessible, you know, and that is based on what the service is, what's being provided. You know, if it's an ER, it's got to be available all the time. But if it's something else that's, you know, that maybe they don't need more than once a month, once a week, as long as that's readily accessible, that might be an option. Of course, you can alter things, you can remodel, you can construct new facilities, you can change policies and procedures to allow for these types of things. You know, in some of these cases, it's, you know, making materials available that maybe wouldn't be available, making someone available that, you know, has sign language ability. You know, maybe something simple that you already have available to you. You just may have to consider how do we address some of these issues that come up. Okay, and then the second one is just saying if you can figure out a way to make something accessible, you don't have to make a structural change. Like if you move an office from the top floor to the bottom floor, it's accessible. You don't have to get a wheelchair to the top floor. And then this, I think, is also important, the fourth line down. The priority that things are given. That comes into our analysis. And we'll talk about that on another slide. But one part that I was confused about when I first started looking at these statutes was it requires that you provide services, programs, and activities to individuals with disabilities in the most integrated setting appropriate. And that is not well defined, what that means. But I have found some case law where they were looking at children's play equipment. And what they were saying is, it's a good example, if you have one piece of equipment in a playground that a child with a disability can access and the rest he or she cannot, that's not an integrated system, right? Or if there's a couple of different parts to a program, one office is accessible but the other isn't, we need to think about integrating that to make sure that the whole program, service, and activities is integrated so that it is accessible. And by default kind of saying, just saying, well, we put in, one piece of playground equipment that is accessible. The federal government's saying, no, you have to take a more integrated approach to make sure that these are addressed. But we're not seeing a lot of cases on playground equipment, just so you know. Just an interesting example. And then, like I said before, for state and local governments, you have a higher standard than that readily achievable. So that's just good to remember because there is going to be a lot more case law on readily achievable. That's kind of what people think of when they think of the ADA. But here, you're required to do that analysis where, if it's expensive, well, what can we do? And even if we can't accommodate someone with a specific disability, have we accommodated other types of disabilities? Okay, and this gets more into depth on the dates. There was kind of a window between 2010 and 2012 where you could choose what standard you applied when doing alteration or construction. However, anything past 2012 we're just going to be in the new standards. So I want you to have that and know that may limited. If you fall into this 2-year window, there may be an additional defense, but generally it's going to be a fairly small area, and not a lot of stuff's going to fall into it. Okay, and then of course we talked about how in 2005, if it wasn't in compliance with 1991, you can't bring it to the 1991 standard. Now you got to bring it to the 2010. Okay, this is getting into some of our defenses that we're going to look at, and this factors into your analysis of if a claim is brought, whether it's going to have any legs, right? Structural and practicality, I think getting into historic buildings, we're going to see that a lot more. Load-bearing walls. I have a restaurant that we had a case on, and the bathroom, one of the bathrooms is through another doorway, and the way the building's made, that corner is load-bearing. If we widen the doorway, first it wouldn't be readily achievable. It costs a lot of money, but it's an old building. The way it was constructed, it probably wouldn't be practical to move that doorway or to widen it. And so now you've got to be thinking realistically, but there's a lot of situations, like this. The Salt Lake County, the old county building downtown, they had those high stairs. Putting in a ramp there is probably not structurally practical. That would be, to meet the slope requirements, we'd have to go all the way out to the street, or go up and down. And so you have to, there may be options that are saying, well, it's not structurally practical, but we're going to look at other things, or install a platform lift, those types of things. Just because a case comes doesn't mean you have to do what the plaintiff wants, right? They don't decide how we fix it. We just have to make sure it falls within the code. And then, of course, as we discussed, even if we can't do everything, we drop down to those second tiers of analysis. Have we done what we can, and have we accommodated other types of disabilities? Okay, and then this is a very confusing part of the code. If you're reading CFRs and you're confused, so am I. But it's talking about path to travel to an area of facility that contains a primary function. A lot of state and local government buildings have a lot of functions, right? And so that it's kind of confusing, but if there's an area that has a primary function in that building, and you're doing an alteration that affects an individual's ability to access that area, and that includes restrooms, phones, drinking fountains for that area, you have to analyze how much it would cost on the alteration to add it, to make it accessible, right? And this is difficult. But the standard is greater than 20% of the total alteration, okay? And that means you take the cost of the alteration, the whole alteration, and take the cost of adding in whatever it would be to make it accessible, if that's greater than 20%, okay? So it costs 120% to do the alteration, basically. And that's a hard thing, but by talking about that and looking at it, and if you're having a contractor come out and make a bid, and there's an issue there, having them say, well, this is how much it would cost to add that in, that creates a very defensible position for us in these types of claims. Of course, the standard would be try to make it accessible, but if that's not an option, especially with these historic buildings, even just showing that you looked at it and you analyzed it and you made a decision will really allow us a lot of leeway. And once something's put in, if a court comes back and says, yeah, you didn't look at it, it would have only been 15% of the cost. It's probably going to cost a lot more than 15% to go in there and redo what you did with the alteration. And so just making sure you did that will save money in the long run, I think. And of course, even if it can't be made completely accessible, everything you can do should be, accommodate disabilities, even if you can't accommodate everyone. These are the priority that we're going to be looking at, okay? And you're going to, you start at the outside of the building and work your way in, basically. Accessible entrance, accessible route to whatever's there, right? If prosecutor's office or whatever, even if they get into the building, if they can't get to where they need to go, that's the next priority. And then, and this is pretty close to what commercial facilities are as well, accessible restrooms, accessible telephones, although we're not really seeing much of that anymore, accessible drinking fountains, and then it kind of goes down the line. And what this is important for as well is if you say, look, we know we have these issues in the building, this is our plan to fix them over the next 5 years. This is the path you want to. This is the path you want to take. So if we get a claim, we can say, yes, we know the bathroom isn't or is in violation or not in compliance, but we just spent all this time addressing this issue, to make sure they can get in. We're addressing now the accessible route, and that is going to show, you took those steps to decide, undue administrative or financial. You're spreading it out over several years. That's where a court's going to be more likely to say, except, yeah, that's a defensible position. There's not a violation there. Okay. This is the link. The government's put together a pretty good list of the CFRs. So that's the 280-page one. The nice thing about having it all together is, of course, it says, the slope requirements have to be in some other section 50 pages down, and the handrail requirements is another section 70 pages down. But when you pull it together, it's pretty quick flipping through there. It's a lot easier than doing it online. So I put that out there, and then there's also the guidance is on there too, and that's basically discussions of why they came to the rule. You probably won't get into reading that. It's not very fun reading, but those are there. I use these standards a lot. I take it with me when I go inspect a building, and because the plaintiff will say it's ramp, it's slope, it's bathrooms, and we can just flip through and say they mismeasured the slope or this and this, and get rid of those easy, and then see what we have to fix. So, and like I said, you may want to double check your contractors. because it's confusing for me, and I do a lot of statutory interpretation, and contractors generally don't do a lot of statutory interpretation, so it's just something to be able to look at and say, yeah, this is what the slope needs to be. This is kind of breaks down how to get through those standards. Chapter 1 and Chapter 2 are application and scoping. Just so you know, scoping is basically it's saying, these are there's different types of rooms, and these are what's applicable to those types of rooms. And then as we get into chapters 3 through 10, they're going to talk about the specifics of each one. So they may say, well, an assembly room means, all sorts of types of different rooms. But these chapters 3 through 10 are actually going to tell you what the size the seats need to be in the assembly room, what the toe and knee clearance need to be. Chapter 5, parking spaces. I think the scoping in Chapter 2 tells you how many parking spaces you need per building, how many van accessible spaces. That's where this really looks like a federal government document, and then it says, in Chapter 2 it says, okay, check Chapter 5 for how wide those parking spaces need to be and how wide the access aisle is. But as you go through this, the standards I told you about in that internet link. Oh, and I forgot to tell you, there's an underscore on that link which you can't see from the underlining between standards and index. So between standards and index, that's underscore index there. Okay. All right, so now we're going to do a little bit more on preparation. What we see in a lot of these complaints. Like I said, it kind of tracks those priorities. Accessibility to the facility, curb ramps. Can they get a wheelchair? And not always, but most of the cases we get have to do with wheelchair access. There's other things as well, but that's what we're seeing right now. Is there a van accessible sign? Are the spaces wide enough? Are there enough spaces? Is the slope of the parking lot within compliance? And then, it'll go through, okay, if it's a restaurant, are there accessible seats? Is the cashier area accessible? One case we had, the counter was too high for the sauces and condiments, right? That's a complaint they made. And so that's, it's different types of things. If they're going to the courtroom, the clerk, how high is that counter? So they can talk to the clerk or sign a paper or do something like that. That's where the next step's going to be. And then restrooms is going to be the big one. And that's where we see a lot of kind of ticky-tacky complaints. But I would say if you kind of do an inside-out analysis, first of all, the parking lot, if you got your van accessible signs, your lines are painted, there's a chance they may just drive right on by. However, if they stop, if someone stops to look at it, they're going to come inside. They're going to go to the restroom. That's a given in these types of cases. And a lot of those things you could address yourself without a contractor. The signs you probably buy on Amazon and put up. Is it 60 inches above the ground? That's the only requirement. Are the parking spaces 96 inches wide? You get out there with the tape measure and a can of paint, really, and you can fix it yourself. And save the county $2,000 or $3,000 in 10 minutes of work in a lot of cases. Some of the other ones, like accessibility to restrooms, in historic buildings, noting that there's a violation and talking about a plan to address it also might be enough. So if a case comes up, we can say, well, they looked at it, it's an undue burden, this is the plan, or that building's getting remodeled in a year, it doesn't make sense to tear out the bathroom now when a remodel's coming through. Something documented to show that, in something like that, we could probably kick this out in one motion, and really save a lot of time. Or in a lot of these cases, I can call up the attorney and say, this is what you said, this is what's happening. We're gonna, we can spend a few $1,000s writing a motion, and Sometimes they'll just give us a nuisance fee of $1,500 or something like that to sell the case. But I need ammunition, to go to the attorney, and that's where I get it from, addressing those little things and having that plan in place. Okay, and this goes over kind of a breakdown of the decision-making process. So structural impracticability. It's not enough to say it's structurally impractical. Is there another route, doorway? You put up a sign that says, there's a door around the side, wheelchair accessible. Have all the non-impractical options been exercised? Same for cost of alterations. I just wanted to give you an idea as you're looking at some of these issues, kind of to go through and say, you can look at a lot of buildings and say, this is structurally impractical. Impractical, I can't say that word today. But going through there and make sure you complete the analysis, and that way, even just one email, where you say, hey, I looked at this is the situation, these are my thoughts, maybe we put up a sign and address some of those issues, can really change, from being an issue to being a non-issue. Okay, and then of course, depending on how many facilities you have or satellite options, allowing, if you have something in a high school once a month, something like that, you may be able to figure out an option that's free to you, right? An employee goes to somewhere else and sits for a couple of hours a month, and you just put it up on your website and let people know. It doesn't cost you any more in labor or anything like that. There may be options like that. And as you think, I'm just kind of suggesting think outside the box, because as state and local governments, you provide a lot different and varied services than like a McDonald's, right? McDonald's is looking at food. Can they get in and eat the food, where you're looking at services, some of which are more vital than others. And that also may create more liability, where a judge is going to be less likely to say, slap the hand of McDonald's. It's a small issue, where with the county and the state and local government, they don't have another place to go, right? They're a resident of the county. They need something from the county. They got to come to you, and so that just allows us to be more responsible and lessen our liability. I think some of the preparation things and what we're doing today is, educate maintenance and other staff. Generally a lot of these are fairly simple. Dispensers, mirrors. You can look at the ADA standards and say, well, 48 inches for soap and paper towel, right? Make sure your staff knows. I think a lot of the cases we've had, dispensers get knocked off the wall all the time, right? It's 3M tape, which a lot of them are put up on. Someone goes in there, they put on new tape, they stick it up, right? It's 49 inches, it's 50 inches. And we get a violation. It costs $10 to fix, it takes 10 minutes. But those are the types of things that you can address, and by even just saying it to people, it may never be an issue, because they'll say, oh yeah, we got to make sure it's under 48 inches. Mirrors, or the reflective edge is 40 inches. These are pretty simple things to look at and to adjust. And I don't know why, but we get a lot of mirror complaints in these complaints that the mirror is too high, and it's because it's in the statute. I don't even look in the mirror. I don't have a lot to look at, I guess so. And then, like I said, identify those that can be addressed. That makes it easier to go to the court and say, we're working on this. We've addressed the low-hanging fruit. I don't want to take up too much time. One other thing to think about here is think about your community and your state and local government specifically. Like I said, it's a very different situation. You may have a historic building with more issues. You may know of a resident who's more likely to bring an issue with a disability, or and can address that. Like I said, play areas. The kids aren't going to bring them, but parents might. Look at what the vital services are, and make sure those are accessible. Even if you have to move things around. And if there is a complaint about accessibility, in these types of cases, I haven't had one yet where they complained to the entity that there was an issue, right? But like I said, in a state and local government, because of the type of service it is, you're more likely to get a complaint from a resident who really wants access to something, right? And even if they don't want access and they're just doing it for whatever reason, it's still a violation. But you're more at risk because there's nowhere else to go, right? For state and local governments, for a lot of these, you're not McDonald's. There's not 50, within 10 miles. And so if you get a complaint, and that doesn't mean you have to fix it. That just means address it, talk about it, go through the analysis. Because if we get into these cases, the first thing they're going to ask us for is whether there have been any complaints, right? That's the first discovery. They're gonna want us to look for all of that type of information. And so if we say, well, yeah, we've had 10 complaints about this in the past 2 years, the judge is a lot less likely. One of the factors of the judge saying something's moot is the likelihood of it happening again, right? And so in most of these cases, we could say there's no likelihood. We didn't know it was an issue. We addressed it. No one's going to rip a dispenser off the wall and put it higher after the case is over. But if there's situations where their complaints were received and not addressed, then it'll be a real uphill battle for us to win those motions for summary judgment. And so that is kind of it's a lot of information, but I wanted to give you an idea, and hopefully the handout will allow you to walk through that analysis. Are there any questions? My presentation's so excellent. I covered every point. Okay. If you do have any questions, of course, you can talk with Kristen or myself. These are very fact-specific cases, but generally, the first step is, can we repair or address these issues quickly? And because of the higher standard, the chances of us having a defense saying we can't is lower for state and local government. And so, if we can, great. But the easiest thing is avoid having someone drive by, seeing you don't have a van accessible sign. Avoid having. Once you know that it's 48 inches, you can go into a bathroom and say, that's too far. Or, if you have a really deep counter, it's 30 inches back. You could in one day you could probably look at every bathroom and take care of 90% of the problems in a restroom. And so, that will, even if they show up without that low-hanging fruit, they're not going to take a lot of time generally to measure things and look at slope if they don't have those kind of easy things. So hopefully you don't have any of these cases, and if you do, let us know. And we've been pretty successful at resolving them for low dollar amounts when we can repair those things quickly. So, all right, and that's everything I have.